Hey, good afternoon, everybody. I told you 2 o'clock. I tried to be on as close as I could. I have, I'm tagging a few people. I'm going to show you a few posters today of what our keywords are, so you have something to look at. Okay, so today, keywords. Oh, look at my messy table here. Keywords: FFPSA, ADA, $50 million. In Q10. Okay, while you're looking at those, I'm going to get a few people invited here. I have a lot of information and things I want to talk about. Again, I always like to keep these pretty compact and informative, and I've been studying a lot on a lot of new things, or not new things, but just a lot of things going on in this crazy child welfare reform. So here we go. I'm going to invite just a few more, and then if you all just pass it around or invite a few more people, I would appreciate it. I always just pick the top ones that come up on my hit list, so if I don't invite you, don't take it personal. Just like to do this as quickly as possible so we don't waste a lot of time. Good. All right, that's all I'm going to do. All right, so those were two of the keywords: ADA, FSPSA, Q10, $50 million. All right. So first I want to talk to you a minute about kind of why I haven't been speaking up too much over the past few months. My life from mid-August to mid-November has been just a rampage of deadlines and briefs and trials and challenges and worrying about the election, and I just couldn't even kind of wrap my head around putting things together that I wanted to talk about. I have posted some videos. Most of them were on one or two particular cases, and kind of emotionally charged because I'm so upset and I get so frustrated with what is going on. But today I have a few things that I pulled out and I'm studying. It's informational. You might want to make a few notes, or you might want to watch it later and pick up and make a few more notes later. But I'm going to talk about, first of all, the FSPSA. That is the Families First Prevention and Services Act. It was passed in February of 2018 in the Budget Omnibus Bill. Now, there were a lot of grassroots lobbying efforts that went on to try to regroup what we were doing with Title IV funds, which are all centered around foster care. We did get the bill passed. It had originally passed in Congress and then kind of got hung up in the Senate in 2016. And then after the election, it just sort of sat in no man's land. And then when they had so much trouble getting the budget passed in February of 2018, it got snuck in thanks to Congressman Buchanan out of Florida, and it did get passed. It has all kinds of problems. It's not a panacea. It's not the best thing for us. First of all, number one, it's optional for the states. So it doesn't remove Title IV funding, and it is optional. I've printed off some things here, and some of the things I have posted. So this is going to appear backwards because I'm just going to hold it up so it'll appear backwards to you. But I posted, I uploaded a couple files. One of them is called the Families First Prevention and Services Act Summary, and the other one is the section by section. If you want to just kind of have a general overall knowledge about it, I would just recommend that you pull up the bill summary and take a look at it. Here's basically what it does. So everybody involved in this probably knows about Title IV funding, that it is only goes to the states if they put children in foster care. Part of the SSPSA is to redirect those funds for children who are at risk of foster care, is what they call it, and to give them services for the first 12 months while they're at home, which includes some intensive in-home services and I don't even know. I mean, most programs I have to say that I've seen state agencies do are not very good or pretty ineffective or unqualified people. So I don't have a tremendous amount of trust in what they may be doing, but that's what it's supposed to do. Second, it is under Title 4B funds. The Title 4B funds have been the funds that are geared towards services for a family, for family preservation, and for while children are at home. The Title 4B funds have historically been about 10% of what the Title 4E funds are. So if you have $8 billion going out in Title 4E, you have like, 999 million or something. I mean, it's like 1/10. I don't have those numbers with me. I've posted them before, but it is 1/10 of that amount. So, and it is limited. So it is only limited to a certain period of time. So this takes away the time limitation on the Title 4B funds. We may have some success in convincing the states to apply that, but it's going to be a really hard shift to get them to redirect the Title 4E funds, and partly because we have this huge industry, this huge foster care private industry that has a lot at stake here. It also provides for a kinship navigation program. It's, again, not very well defined, but it's supposed to help promote kinship and permanent guardianship through kinship. That's part of it. Another thing that it does is that it's trying to reduce the number of group homes, and it's putting more limitations on when the state can use group homes for children. And it's really kind of interesting. I'm not sure when it becomes a group home, because foster parents can have up to 6 foster children, and then it even says that there are exceptions if they have like sibling groups. So, basically they can have 4 sibling groups with 2 kids each or 3 kids each and have a whole lot more than 6 children. So I'm not sure when it actually qualifies as a group home under this plan, but it is to eliminate the need for group homes. It does reauthorize incentive payment programs for adoption and legal guardianship. So for all of us who was really hoping that we're going to make some headway in eliminating the ASFA adoption incentive, it's not going to be in here. So I want you to be aware, and I'm going to hold this up again. Again, it's going to look backwards to you, but that is the FFPSA, Families First. I didn't even write it right on here. Families First. Services and Prevention Act. Prevention and Services Act. Yeah, Prevention and Services Act. Excuse me. Families First Prevention and Services Act. So that is, if you really want to become very knowledgeable, the section by section I put up as a file. You'll see this. You can go through here and look at more specific things that they're supposed to be doing with their programming. If you are currently involved in a child welfare case, I highly recommend that you pull these off and have a copy of them with you. If for nothing else, you can use it to kind of put in their face and say, the whole purpose of the changing program is for children to be supported at home. That is the trend. That's where social welfare is going. And so maybe you can encourage them. I mean, sometimes I've been able to use things like that where maybe I can't point to a specific policy, but I can show that that's the direction. And I've done that some on ADA, and I'm going to show that to you in just a minute. The next thing I want to talk about is medical kidnap. Everybody knows, I believe, Terry LaPointe, who's part of our group, and she writes for medicalkidnap.com. She writes amazing stories about parents whose children are taken away from them for various circumstances which involve medical kidnapping. It can be trying to get a second opinion. It can be babies with brittle bones that become fractured. We have this whole question of the shaken baby syndrome. It can be for what they consider to be malnutrition. So the medicalkidnap.com is something that is, I've worked with Terry on. She's done a couple of my stories. She does an amazing, awesome job. So I think because they've done so well and made so much progress, the opposition is heating up as to the medical kidnap issues. And there is an article that came out. Let me get the date on it. It says here September the 26th, and it's by ProPublica. Now, for those who do a lot of online news, following different news groups, I will tell you ProPublica is a very, very left-wing, government-intensive platform, I guess is what I want to call it. And they have, they're anti-Trump, they're very, very left-wing. So they have done this article on Dr. Hollick. I'll hold this up. Again, it's going to be backwards to you, but it's going to be easier than me flipping the phone back and forth. I will upload some more of these so you can take a look at them. Dr. Michael Hollick is in Boston, and he has been an expert in over 300 cases related to children who have fractured ribs, babies who have fractured ribs, and has helped parents get the proof before the court on the brittle bone syndrome, Ehlers-Danlos syndrome, osteopenia, osteogenesis imperfecta, some of the medical conditions that can cause babies to have very brittle bones. He had studied vitamin D for years. He's done hundreds, thousands of peer-reviewed articles on vitamin D and the effects of vitamin D on health. But he's being highly, highly criticized for the position that he's taken on Ehlers-Danlos and brittle bones in babies. It is, I'm going to go ahead and just take a minute. I've gone through all these stories and highlighted a lot in here that I think are very important. They criticize him because in the 300 cases he's testified in, he's always testified for the defense and saying that it's not child abuse. Well, he's criticized for that, and yet I say the child abuse medical experts at these children's hospitals are always testifying for the prosecution. And some of them say they testify for the defense, but I've never seen it. So, and they always testify that it's child abuse. He's also criticized for, hang on here. It says he has published more than 500 articles of peer-reviewed journals and more than 200 reviews and book chapters on vitamin D. So it's not like he is, an idiot or that he's a quack. So he has a lot of knowledge. He talks about there being 13 types of Ehlers-Danlos syndrome, but he gets criticized give me a second. They go through in this story several specific cases about parents who are charged and prosecuted, and it needs to be taken very serious because when they talk about him in the story, parents can be served 20 years in prison for a child with fractured bones. And when you look at, because I've done these kinds of cases, they sort of criticize Dr. Hollick for saying that the child has a medical condition that would make his bones so fragile that they could incidentally be fractured, which means, and incidentally, I mean by normal handling, by changing a diaper, that they could receive a fracture or sometimes even a sort of a brain bleed or a bruising between their scalp and their skull. But then a lot of the injuries that these child abuse experts go in and testify to, they are asked, I always ask them, what is the mechanism of the injury? Let's talk about, for instance, the fractured ribs. There are cases when an infant has fractured ribs. Those fractured ribs will be anywhere from 12 to 32 fractured ribs. And they're all at what's called various stages of healing. So they call it multiple fractures at various stages of healing. And that is considered to be diagnostic of child abuse. And yet when you think about it, you have to say, so what do you do? Pop a rib a day? And is it just a certain amount of handling that causes one rib to fracture and not the other ribs to fracture? These ribs are never displaced, they're never like separated totally. There's never a lot of bleeding around the healing. So there are these child abuse medical experts that go to court and say that it can only occur by abuse. and yet they can't really explain the mechanism of the injury. So it's very troubling. Shaken baby is the same thing. Shaken baby has been, it's been out there 30 years, and it's been this theory. And as a prosecutor back in 1994, I even was presented with a case that was supposed to be a shaken baby syndrome, and where there's bleeding around the head and the brain and yet in the retina, and yet there's never any neck injury, and supposedly you're shaking a baby so hard that it would cause the back of the eyeball to tear, and yet there's no neck injury, or it would cause your brain to bounce around in your head, and yet there's no neck injury. So there's a lot of questions about these, and we have got to get the medical community to be more in tune to looking at the real medical cause of some of these injuries. And I don't know what it's going to take to get there. We need some really strong, aggressive doctors. We need parents to speak up. We need parents to ask questions. But we've got to be persistent in it. I will, if you all would like, I will upload this. I'm not at home today, but I will upload this article as well and post it so you can read it. It's called The Child Abuse Contrarian, Dr. Hollick. And if you would like to be more educated in that, it's a really good article to read, because we have got to surround parents who are involved in medical kidnap situations and help educate the courts. I've done that. It's really hard to do. The attorney has to be willing to be educated on it, because you can't just set a doctor up there and say, ready, set, go, and let them talk. Okay, hold on one second. I have a little disturbance in the background. Hang on with me. Miss Yelena, you need to turn that down, please, and do not turn it back up. I'm sorry about that. I have a grandchild in the background watching TV, so thank you for being patient. All right, the next thing I want to talk to you about is a Department of Justice report that came out September the 25th, 2018. It is... it's titled, Hospital Chain Will Pay Over $260 million to Resolve False Billing and Kickback Allegations. One subsidiary agrees to plead guilty. All right, so this is about health management associations. Now, first thing you're going to say is, well, Connie, this is not directly related to child welfare reform. Why are you doing this to us? But it is associated with, and you need to be educated on how they got to this point. This is basically community health systems was gouging Medicare and Medicaid, because people would come into the emergency room and then they would admit them to stay in the hospital. And plus, not only that, they were giving doctors things like free rent to be able to refer patients directly to the hospital. So ultimately, it got up to the Department of Justice, and I'm going to tell you how in just a second, but it got up to the Department of Justice. And then they were criminally charged, and then they were fined, and they are going to pay $260 million. Now, let me tell you how that relates to child welfare reform and why that is important to us. Is the way they got before the court was under, again, it's backwards, Q-U-I-T-A-N. Do you see that? I'll turn it around for you at the end as well so you can look at it. And I think I posted it as a subject on this video. A QTAM report, or QTAM action. So a QTAM is a whistleblower action that can be brought under the False Claims Act. And then it allows private parties to sue on behalf of the government for false claims and to receive a share of any recovery. Now, we know that there are a lot of fraudulent uses of Title IV funds. And specifically, I know that a lot of children are either placed in foster care that either do not need to go into foster care, or they're put into foster care and they're held in foster care beyond the time limit that the family has actually gone through the rehabilitation process. Or that they could have been placed with a relative. So there are tons of violations on the foster care Title IV funds. This is one thing we've got to start wrapping our heads around, that we can we can bring to the courts on a False Claims Act, a Whistleblower Act against the Title IV E-funds. We all know that they're private agencies that are doing this, private contractors making tons of money, and I'm going to start wrapping my head around that and ask you to, as well, in your own jurisdiction and venue, to identify specific cases where, again, either the children are removed and put in foster care when it was not necessary, or the children are retained in foster care after the time period that the family had rehabilitated. Okay, next thing I want to share with you, moving right along here. Whew, it's already been about 20 minutes, so I've got a whole stack here to go, so I may just quit in a few minutes and come back on after Thanksgiving. All right, this is, I found this very interesting. This says, state prosecutors investigating whether ex-Baltimore Social Services chief properly placed foster babies. Okay, it's backwards, I understand that, but I'm going to post this so you can read the story. Now, the reason why this story is so important is because a few years ago, when I was going through YouTube, searching for CPS corruption stories to find out what was going on, one of the TED Talks that I saw, and I'm sure, and I've posted several times, and I'm sure most other people have seen, is the Molly Tierney TED Talk out of Baltimore. So this is a story about Molly Tierney being investigated. Yeah. So she goes on TED Talk and talks about how foster care is, messed up, and what a great job she did, and how she reduced the need for foster care. So it goes through here and it talks about why she's being investigated. So one of the reasons she's being investigated is because of whether or not she followed the proper procedures for placing 2 foster babies with the CEO of a nonprofit in 2016, where she had been on the board of directors of that nonprofit agency. And then whether they are questioning the expenditures of $7 million in public funds that she awarded to the nonprofit Family League of Baltimore, where she had worked prior to working with the agency. It says here, the financial audit made no mention. Oh, this is a little bit of it. A little bit different. There's a couple different things being investigated. One of them is the financial audit, and then one is her placement of babies. Kind of scary. So she placed 2 foster babies with a former CEO of Family League. Now, Family League is the very same organization that she that received $7 million in public funds. That's all pretty scary. And she makes the comment through her attorney. It says, well, all adoptions are approved by the courts. So, of course they are, but the court doesn't always get all the information. The court doesn't, when they do a home study on the placement for adoption, they don't ask, what's your financial association with foster care or with the director of the agency. But it goes through here and it talks about how this pre-adoptive family was actually called from the hospital and told that the babies were being born. There's some significance here that this is a mom who'd had some drug issues, and she tested positive when the baby was born. And she ended up leaving the hospital before the baby did, which, again, is not unusual. If you have a baby that they believe might have some drug exposure, a lot of times they will keep them a day or two. And it doesn't tell all the details, but it does say that she left the hospital before the baby was allowed to be the hospital. And then what happened is, and I don't know whether the hospital social worker did it or whether the agency did it, but they reported the baby as being abandoned under the state law for abandoning babies, which they have in most states now. And when they reported it, the baby as being abandoned, they were able to seize the baby and immediately place it in this pre-adoptive home and then go to court like just 2 or 3 months later. So it talks about how they are challenging that, and the mother wants her baby back, basically. It's really interesting, too, because I was just in Court of Appeals a week and a half ago, talking about how this California agency had swept into Tennessee and gotten this mom to sign away her rights and under documents that I think were illegal. So we'll see how the courts are starting to deal with that. So that's the story of Molly. Interesting. Okay, so Florida, here's another, this is November the 19th, 2018. Florida is suing Walgreens and CVS for playing a part in the opioid crisis. Again, maybe a little bit off from what we're doing, but we all know that the drug exposure and drugs during pregnancy is like a sure thing. You're going to lose your baby if you took an Oxycontin while you were pregnant and they get one positive drug screen from you in Tennessee. They can take your baby away and say it's severe abuse, whether the baby's born clean, whether you're clean at birth or whatever. So this I find kind of interesting. It talks about Attorney's Florida General Pam Bondi is the one who is initiating this. I kind of have mixed feelings about General Bondi. I think she's bucking for some political appointments here, so she's taken this very aggressive stand on a very hot topic. But the part of the reason I wanted to talk to you about this is if we make foster care, forced foster to adoption a hot topic, that we can, then we get attention. So we have to keep talking about it, as frustrating as it seems sometimes. All right, keep going. I got another one. This is a memorandum from the Office of the Attorney General from Jeff Sessions about the day before he left office, November the 7th, 2018. Somebody had sent me to this as it had been through ProPublica. They had written a story about this memorandum and made it sound really, really bad, which when I tell you what it's about, you'll understand why I am saying that ProPublica is has a very liberal, anti-Trump, anti-current establishment view. Jeff Sessions, now whether he had prepared this before or they were putting it together, ProPublica made it kind of look like he had sort of snuck this in prior to leaving. I doubt that happens. You don't write a DOJ memorandum in a week. It takes months to put it together. But what this memorandum is about limitations on the federal government in stepping in and controlling the state functions. And where they will have, I think a good example is probably the city of Ferguson, where the DOJ went in and sued for racism within the police department. And then the federal court can assign a monitor, they can enter a consent decree, and they have to have this monitor, and that monitor gets paid, and there's a way to select a monitor, and then they keep an eye on them. It has good and bad. I mean, there's been a lot of these happen under the children's rights. Children'srights.org did several class action lawsuits in the 90s and beginning and through the millennial. And they would have a monitor assigned. And Tennessee was under one called the Brian A. And they had Andy Shukoff got assigned to be a monitor, which I'm going to talk about again in a second, but the DCS had to pay out $1 million a year for them to monitor their performance, although that was never made public. There was no opportunity for citizens to file complaints or have any direct response with the monitor, but it is set up through the federal government. They talk about that if it is going to be used, it has to go directly through the Attorney General or the deputy. And then it also just talks about how there needs to be limitations on it, and it goes through some very specific things about it can't be long-term, it has to be very specific, the monitor has to, they have to have time periods where they return to court. Now, why am I talking to you about this? Again, this gets back to Title IV-E funds. We have got to have some changes to Title IV-E funds and their use. Exactly how we get there from here, I think there are a couple instruments that we need to look at. One is a QTAM. Perhaps we can get into get with the DOJ as far as bringing an action against them, and then maybe getting these funds monitored by somebody who's responsive to the public, because that's really where it needs to be, who has a reporting system directly to the people who are participating in the programs. This has been one of my big complaints all along. They say, well, we have an ombudsman. Ombudsman is nothing, is a total waste of money. They should just be eliminated, but they haven't been. All right, I've got just a couple more things to do. I want to talk about ADA. That was one of my words here. ADA, it's backwards, but it's Americans with Disability Act. The ADA is, for those of you who've been part of our group for a while, you know that in 2015, the Department of Justice did a report on the story of Sarah Gordon out of Massachusetts. And it talked about how this disabled mom was, her ADA rights were violated when her mother, so the grandmother of the child, had gone to the social agency and had said, let me, take the child as guardianship of the child, and then I can help my daughter parent the child, and we don't have to terminate her parental rights, and the child will be safe. And they had refused to do that, and so the Department of Justice got involved. They wrote this report that came out in February 2015. It's referred to as the Sarah Gordon case. And then in about May, I believe, May or June, something, maybe August of 2015, they did what they called a technical assistance guide that was published by the Department of Justice for the different agencies to apply the ADA. It was during that time period that I was representing a young dad who was in a similar situation. He had some disabilities. He was unable to care for his child on his own, but he had never hurt the child. And I had asked for the child to be placed with relatives. And I got into the case late, unfortunately. So whenever that happens, I have to try to clean up some things. But I had went ahead and pushed more for placement with relatives, and they denied it. And by the time we got to court, they were like, well, it's been too long, now we're not going to do it, which was a terrible reason to say that, but that's what they said, and so it's a mess. So I just went to federal court and I filed an ADA violation. So I filed my brief. This is going to the Sixth Circuit Court, the Federal Circuit Court, and I filed my brief and I talked about ADA from the perspective of employment issues. So there's Title I, Title II, and Title III, and what we're talking about is Title II, and there aren't really very many cases under Title II, but there are Title I and Title III cases where they talk about what is the threshold for a state agency knowing that there's a disability, and then once they know there's a disability, what is their responsibility. So if you look at the case law, it's kind of a triggering step action. You have a person who is eligible for services by a state agency, and they have a disability. So as soon as that disability is acknowledged or noted or documented in any way, that triggers the requirement of the agency to engage in what's called an interactive process with the person in which they can create an individualized assessment tool. They don't do it. As a matter of fact, when this occurred, I looked up the ADA policy of the state agency, and the only ADA policy they had was for internal employment and making accommodations for disability as an employee. They finally, in 2018, I think it was, they made a change to that policy and made it so that it affects parents as well, but they hadn't even applied it. So I've gotten the state's response, and they complain that the request for placement with the relatives was not a request for a reasonable accommodation. And they blame the courts because they say, well, DCS didn't object to placing with the relatives, but when they took it to the court opposed it. And the reason they opposed it is kind of odd. It had to do with some undefined medical issues that could have been, the child could have been affected, but it was never really clear. Again, that was a little bit before me. So here's the deal, though, that when DCS has custody of a child, they are in complete and total control of where that child is placed, okay? They're in total control. I mean, even the statute is clear, and even if you look at your own states, all of our states have things that are different, but there are some things that ultimately are the same. And the reason that they're the same is because under the Title IV law, which is 42 U.S.C. 671 and 673, under those laws, it says that the state must have a plan for the implementation and use of the Title IV funds. And there are certain things in there that have to be consistent. So the state, once a state has a child, they have complete and total control of where they put that child. And if the judge doesn't like it, the judge can say, I don't really like it, I don't approve it, I oppose it, But it doesn't matter. The court can only make recommendations. The court cannot decide the placement. This is so critical. It is really a due process issue. It's huge, but that's the way it is. In this particular case, the DCS had the opportunity, the authority, and all of the requirements had been met to place this child directly with her relatives in another state, and they refused to do it. So I'm just, the fact that the state is now saying, well, but the judge didn't approve it, has no credibility, no merit at all. All right, so here's another thing that's really scary about this. So I'm going to read this sentence to you, and it says, two sentences, sorry. Indeed, other potential accommodations are difficult to imagine in the context of child welfare. The plaintiff cannot care for the child. Any accommodation that would risk impermanence for the child or potentially subject her to future abuse or neglect would be inherently unreasonable. Now, I'm going to read that last sentence again. I want you to listen very carefully and take some notes. Go back and watch this, take notes. This is near the end. I should have put it near the beginning. Any accommodation that would risk impermanence for the child or potentially subject her to further abuse or neglect would be inherently unreasonable. Now, do you know what that is? That is predictive negligence, predictive abuse. If any of you ever watched the movie Collateral Damage with Tom Cruise, where they predict that a crime is going to be committed and they go and they arrest the person before the crime is committed, it is exactly the same thing. It is a prediction of abuse that cannot be relied upon by the state. I read that sentence in this brief and I nearly choked, okay? So, but that's what I'm dealing with. That's what you're dealing with. That's the state of our nation. That's the state of child welfare. All right. Down to $50 million. Okay, talk about money and some numbers. Getting numbers that are consistent and supported is really hard to do. There are certain things that are available on the website, such as the budgets, and you need to take a look at budgets. You need to start pulling up your state budgets. So here's what I've done. I went, and I'm going to take the phone out and show you these numbers so you can look at them straight away. But I went and pulled the state budget. Okay, so hang on here. I'm going to show you state budget. Okay, this is comparison of programs. This is Tennessee. This is Children's Services. Now, notice first of all 3 things here. It says appropriation, federal, current services, and other revenue. All right, now this is the current year. You'll see there are 3 numbers. The top number is the whole amount, which is $816 million. I'm going to take you back over here and look at the 2 previous years, $813 million, $802 million. All right. Now, first of all, I want you to know that nowhere in the report was I able to find out the definition of current services and other revenue. All right. We don't even know where that's coming from. So I'm going to have to find out. Part of it is probably child support that they collect for children that they have in foster care. I'm not sure how DCS has income, what they're selling. It could be adoption bonus money. It could be child support. It's just not clear here. The appropriation, of course, is the amount of money that comes out of the state budget, and then the federal is the money that's coming through federal Title 4E and Title 4B. All right, so you have that in mind here. Let me then take you to the last document, folks. Hang in there. What I have here is, this is the annual report for the Department of Children's Services for 2016-17, okay? That's a couple years ago. They talk about what a wonderful job they're doing, but I want to take you to this page over here. Be patient. Oh, they have all kinds of stuff. This year's highlights, blah, blah, blah. Now, they have, I used to pull these budgets off every year, and I got a whole lot more information. Now they kind of whitewashed it. And here's what I want you to look at. Okay, this is the Office of Finance and Budget. Now, you'll notice here, it says, DCS managed a total of $767 million in budget and resources. Okay, now remember over here, if we look at 16-17, it is $813 million. So there is $50 million missing from this budget. $50 million. Yes. So I'm going to show you another number now. When I try to find out numbers of children in foster care, a lot of times I will refer to a website called kidscount.org, which is getting pretty outdated. I don't know if they're not keeping up on it or what. But I often use the number for Tennessee of being about 7,200 children, which I got from kidscount.org. Now, I looked at this report, and it says DCS by the numbers, and it has here all the different regions. And here, it has children in custody by adjudication, and it is 14,421. So we are either getting very poor numbers from kidscount.org, or they just don't report everything. Just can't tell. But that's 14,000. Interesting number. Now here I want to show you something else. A lot of people will try to say that children of minorities are disproportionately put in custody. This is children in custody by race. And looky here. Asians, pretty low. American Indian, very low. American, Black African American, 3,400. And looky here. White, they call it, 9,900. All right, so we have almost 3 times as many children that they term as white children as they do as African American children going into the system. Look at that. Found that very interesting. Also, I want you to take a look at this. You know, those of us who are fighting the forced adoption, look at these numbers. Time to permanency for custody exits by time frame. And the highest number of children they're even dealing with. Look at this, 0 to 12 months and 12 to 24 months. Look at that, 67% and 25%. Whew, horrible. Oh, now this is interesting too. This is getting to the end here. Thank you for being patient. This is active placements during the 2016-17 year by region, level, and type of placement. Now, first of all, go over here, and I want you to know that they consider a trial home visit a placement, which I found very interesting, because a trial home visit means that the child has gone back to the parents and they're just under somewhat limited supervision, but they consider that a trial home visit. I really wonder if they're continuing to get federal funds for that time period, because I'm not sure why else they would have it listed, be graphing it on their charts. And then they have what's level 1, level 2, level 3, level 4, which is the level of care needed for the children, etc. But look here at this number. 35,000 children. This is just Tennessee. Okay, that is everything I wanted to show you guys. All right, y'all, thank you. You all have been very patient. I've gone way over the amount of time that I like to do, but I wanted to give you some information that I've been learning about, been watching. We have, as you know, a new election, a lot of new governors. I don't know what's going to happen. We've got a governor that I was hoping to get into place, but I've already seen a couple of his cabinet picks or seen what he's doing for his cabinets, and I'm not really excited about it. So it's been a weird year. I can't really say it's been a great year. Tomorrow is Thanksgiving. I do want you to take a few minutes and be thankful. If you do not have your children, I am praying for you, and I want you to keep fighting. Just keep fighting. I've seen kids come home after 7 years. So I love you, and I'm still working hard for you. I put up with this nonsense every day. So I'll continue to work, and I look forward to talking to you again. Thank you so much.